This is Phil Rizzuto from the Rizzuto Law Firm. The deposition in your case is probably the most single important event that's going to take place during the course of this litigation, whether you're the plaintiff, the person who's bringing the lawsuit, or the defendant, the person who's being sued. Right now, we're going to go over some basic principles that you need to know in order to be prepared so you can do a great job at your deposition. A deposition is also known as an examination before trial, or for short, an EBT. It usually takes place at the court reporter's office, at the courthouse, or in one of the attorney's offices. The most important thing you need to know, and it needs to happen in order for you to have a successful deposition, is you have to meet with your attorney. Your attorney can tell you, oh, it's not a big deal, just show up and tell the truth, don't worry about it. But your attorney needs to be as familiar with your case as you are. And it is crucial that you sit down beforehand and go over the facts surrounding your action so you, as well as your attorney, are prepared for this deposition. One thing you're not going to do is review documents beforehand. If you review documents beforehand, the other side will be entitled to copies of anything that you've reviewed. And there may be items or documents or photographs or whatever they are that they may otherwise not be entitled to. One of the first questions you will be asked at the deposition is, did you review anything in preparation for your deposition? And that includes in preparation for meeting with your attorney so you can prepare. There are going to be some basic areas of inquiry that will take place during the course of any action. First, they're going to want to ask you about your personal background. They'll want to know about the facts surrounding the lawsuit, what brings you to court. They want to know about the injuries or damages you're claiming. If it's a personal injury case, they will want to know about your medical treatment. They'll want to know what the present situation is, what your present complaints are. Again, if it's a personal injury case, what your limitations are, what pain you're having. If it's another type of lawsuit, then how this lawsuit has affected you. They'll want to know about your lack of ability to partake in usual activities, including work, recreational activities, and what your special damages are. And your special damages are out-of-pocket expenses. How much did you pay to have something repaired, or for medical expenses, or future medical expenses, or what your future damages will be. The 5 best answers that you can give during your deposition are yes, no, I don't know, I don't remember, or I don't understand the question. That's yes, no, I don't know, I don't remember, or I don't understand the question. You really want to limit your answers to those 5 things, unless you're talking about your damages or your injuries. That is the only time during the course of a deposition where you want to talk as much as possible and elaborate so the other side gets the full scope of how you've been affected. Now, if you're a defendant in the case, then you just want to pretty much limit your answers to those 5 things. And you want to listen to the question and just answer the question. Do not volunteer any additional information, because once you volunteer additional information, that's going to lead to a whole other line of questions and other areas of inquiry, and it's going to prolong your deposition, and you're going to give the other side information that, 1, they really didn't ask for, 2, they may not be entitled to, and 3, may not be relevant to your case. And there's no good that can come from volunteering any information. Again, unless you're going and you're talking about your injuries or your damages. It's important that you let the examining attorney finish asking the question. There will be a court reporter taking down the questions that are asked and the answers that are given, and they're typing as this is being done. And a court reporter cannot type information when two people are talking at the same time. It's virtually impossible for them to do so. To make their job easier, you want to let the attorney finish the question, and then you give your answer. You want to give your attorney an opportunity to object. Why? Well, one, the attorney may be trying to protect your legal right, because if they do not object to a question that's improper, then at the time of trial, they may lose that opportunity to object and protect your rights. So it's important that your rights be protected at the deposition. Another reason may be to alert you that this is an important question and you need time to think about your answer before you give it. So let the attorney object. Now, sometimes the objection may just be to the form of the question, and the attorney will say, objection to form, you can answer. And basically that's to move the deposition along. And generally, all objections are waived unless the question is really improper or the form is improper. But this is stuff your attorney should go over with you in preparing, for your deposition. If your attorney objects to a question because he does not understand the question, the lawyer will generally ask the witness if you understand the question. Okay. You need to take the time to think about what the answer is. And if your attorney is objecting, you should let the examining attorney rephrase the question. It's important that you never give exact answers to certain questions. In a lot of cases, very important elements of the case will come down to time, distance, and speed. And this applies to motor vehicle cases, trip and fall cases, slip and fall cases, almost any personal injury case. It's going to be time, distance, and speed. Once you give an answer at your deposition, you will be locked into that answer at the time of trial. So the best practice in that situation is not to give exact answers, because in most cases you won't have an exact answer, but you will be able to approximate. If you can give an approximation, you should do so. Even though one of the 5 best answers is, I don't know, or I don't recall, if you're the plaintiff and your answer to basic elements to make your case, or I don't recall, or I don't know, you will lose your case. If you're the defendant and you don't know basic answers to the elements of your defense and the elements of the case, you're going to lose your case, right? So you don't want to lock yourself in to give an exact information, but you should be able to approximate time, distance, speed, and dates. And again, if your attorney meets with you before your deposition, all of this should become familiar to you, and you should be well prepared, and you should be able to give those answers. There are a lot of areas during the course of a deposition where you don't want to go into. Right? These are the no's that we go over. You don't want to add because into any answer. Why? Because you're just going to answer the question And when you add in the word because, you're explaining things you don't have to, and you're giving other information to the adverse party that they're not entitled to and that they don't need. You don't want to speak out loud. Never speak out loud, because again, there is a court reporter who's taking down all this information, and as you're thinking out loud and you're speaking it through, the court reporter is transcribing that information. Never assume. All right, and if you're an Odd Couple fan, you will know why you never assume. Again, stick to the 5 best answers. If you don't know, say you don't know. If you can give an approximation, give an approximation. But don't assume anything. Again, we don't volunteer any information that is not asked of us. Don't go into your pockets during the deposition looking for information, because once you do that, the other side is going to want to see everything that you're looking through, and they may not be entitled to it, and it may not be helpful to your case. Don't volunteer to get documents at home, because you may have the best intentions, but when you get home you can't find the documents, and the other side will think you're trying to hide something, and they're going to make a big issue at it at the time of trial, saying, well, you said you would get this and you didn't get it. What are you trying to hide? Don't joke around with the other attorney. Don't be a wise guy or a wise girl. If your county accident happened, you give that information. But there was a situation where a client said, how am I supposed to know? I have no idea. And he lost the case because of that. He tried to explain it away later on during the course of the deposition, but once you commit yourself to an answer and you say, I don't know how the accident happened, well, you're not able to prove your case. The court reporter has memorialized that answer in writing, and you make a motion to the court sees this and said, well, they can't prove their case. Don't ask questions of the other attorney. That's not your job. It's their job to ask questions, your job to give the answers. And do not try to win your case at the deposition. That's your attorney's job. Let your attorney do his job, and you will do great. If you follow these basic rules and you go over the case with your attorney, you're going to do a great job at your deposition, and that's going to go a long way in helping get your case either settled or winning it before a jury. If you're not prepared and you don't do a good job at your deposition, you're going to risk losing the case. And attorneys evaluate the cases right after the depositions, and they'll go back to their clients or their respective parties and say, hey, this person made a great witness, this person made a lousy witness, and that's how they evaluate cases that they should settle, and they analyze their risk at the time of trial. So follow these basic steps. Again, make sure you go over your file with your attorney before the deposition, because this is not a substitute, it's just some basic guidelines of what you need to know. And if you do all of that, you're going to do great. So if this information was helpful, hit like and subscribe. And if you have any questions, or if I can help you in any way, just give me a call at 1-855-Rizzuto. Thank you.